Hello and welcome back to GBNAmerica. I'm very interested today to be speaking to Jeff Swartz, who's going to, I hope, explain to me the recent Crumbley case where a mother has been held responsible for involuntary manslaughter following her son's mass shooting. Mr. Swartz, can you explain to me the legal principles that underlie this and what led to this case coming before the courts and the decision being made as it was?
Okay. Involuntary manslaughter is basically, in this instance, either the violation of a legal duty that is owed to the public to do certain things to prevent harm to others, and that what you did was the cause of the ultimate harm. The other theory is that there was gross negligence in what people consider to be a common law duty, and therefore, because you did not take the first steps or some steps to prevent it from happening, you are held responsible for what somebody else does. And that's kind of the theory that was used here. The problem that existed in the Crumbley case from the very beginning, which really didn't pan out, was that you also have to have that causation I talked about. And there were intervening causes that resulted in the shooting that took place on the part of the administrators of the school, as well as the fact that Mrs. Crumbley said that I was not in charge of the gun, my husband was, and he's the one that hit it, and he's the one that did things, and so therefore I am not responsible because my husband may have violated some duty, but I violated no duty to anyone.
And the husband is also being charged with involuntary manslaughter because he's the one who actually bought the gun, and there are some suggestions that school officials should also be prosecuted in a similar way.
Yeah, the father is responsible, at least according to the mother's testimony, that he not only bought the gun without her knowledge, that she didn't really approve of him having the gun, that in fact the father took responsibility for placing a trigger lock on it and from hiding the gun and ammunition from their son so he would not attempt to use it or play with it or whatever else he wanted to do with it. When they were not around and did not take him to a shooting range, which was the only place he was allowed to have the gun in his hand. As far as the administrators are concerned, there was a meeting at the school before the shooting took place. The administrators wanted the parents to take the child out of school, but they said that he really wasn't dangerous, so the parents said, no, we're not going to take him out of school. We'll pick him up at the end of the day or he'll go home. The administrators, still apparently now having some fear, decided to place him back in a classroom rather than keep him isolated from the remainder of the student body, and that's when the shooting took place. It was their failure to act, that they had a statutory duty to act, that resulted directly in the cause of the death of the 4 kids.
And how old was EthanCrumbley at the time of the shooting?
He was 15 years old.
He was 15 years old, but oddly, he was charged as an adult and sentenced as an adult, whilst at the same time his parents are being prosecuted for him as a child. Isn't that inconsistent, and shouldn't the courts settle that one way or another? Either he's an adult or a child.
Okay. Chronologically, he was still a juvenile. What happens is it's not that he's charged as an adult, that you are an adult person. They charge him in the context that he is mature enough to be responsible for his acts as an adult and to be sentenced as an adult, which is what happened. They did that because in the United States, juveniles cannot be sentenced to life without parole, except under specific circumstances. They held a hearing and said, we're going to sentence him as an adult simply because he's not redeemable, and so therefore he should spend the rest of his life in prison.
So his sentencing as an adult doesn't imply that he had the judgment of an adult, because obviously if he were genuinely an adult at the time of the incident, his parents wouldn't have a liability, I wouldn't have thought.
Yeah, if he had been declared an adult as a person who can do all the things that adults do, like contract and get jobs and live on their own and all the things that go what they called emancipation. If he had been emancipated, then they would not be responsible because he is, in the eyes of the law, truly an adult for everything that he would do. Here, this was just a mechanism to provide adult punishment to him for something he did as a 15-year-old.
And does this case have wider legal ramifications? Because there's been another terrible shooting recently. There seems to be a constant flow of these awful murders that take place, these mass murders. Do you think this is going to bring other people into responsibility for them beyond the murderer himself? And I think it is almost invariably himself.
That's correct. The real problem here is that because there was no statutory duty, although Michigan has passed a law that took effect 2 days ago that actually make it mandatory that parents secure firearms, or anybody secure a firearm in their home so that it can't be used by someone else. What the state wanted to prove is that there was a common law duty to do those things, and the failure to do that is gross negligence, and therefore it is involuntary manslaughter. The problem is you can't limit this ruling or this verdict to strictly guns. It could be any type of weapon. For example, if your 16-year-old gets mad at somebody down the block and he comes home and goes in the garage and grabs a baseball bat, and he goes down and he beats some kid's brains out, is a parent now held responsible because they didn't secure the baseball bat? If he runs in the house and grabs a cleaver, meat cutting cleaver out of the drawer and runs and starts chopping at somebody, are you now liable because you did not secure your cleaver? It really is one of those things where there is just a broad array of things that are weapons that now could be used as a basis to go after parents for the acts of their children.
Yes, and not just parents, clearly, that this may well apply to schools as well, and to other officials, and that therefore you begin to spread the net very widely.
Well, that's true. In the United States, school administrators generally have immunity for doing things while they are in the process of carrying out their duties, at least civilly. That's the reason why these two administrators in this case were never charged. One is an administrator in a different school in the same district, and one has moved out of the district and is working as an administrator in that district. And the district they worked for in Oakland County did not want to have them charged, because if they were, that might leave them open to liability for their acts financially to the parents and the families of the 4 children who were killed.
And isn't this, in a way, however you look at it, just skirting round the major issue of the constitutional right to bear arms? As you may or may not know, the UK Bill of Rights, or strictly the English Bill of Rights, maintains the right to bear arms for the maintenance of a Protestant militia. But because our constitution is not codified and can be changed by legislation, we have very, very tight gun control. Your Bill of Rights maintains the right to bear arms for a militia, and yet is almost unchangeable and seems to allow widespread use of guns for evil purposes, but there isn't any will to change that or control that.
There isn't, and that's a major problem. Yes, the Second Amendment is an issue. I teach constitutional law. The Second Amendment is something I talk about frequently. The truth of the matter is that there was a comma that's in the Second Amendment that no one pays attention to in the first sentence, and believe it or not, they just skip over it. In the Heller decision by the United States Supreme Court, they found that owning a firearm is a personal right, as opposed to something that is basically created for the purposes of being part of a well-regulated militia. I've always said the United States was built on 2 things, guns and booze, and guns have replaced booze as probably the most important thing in people's lives. It is really bad that we do not regulate certain types of weapons. It is constitutional to do that. There is a reasonableness standard that applies to the application of the Second Amendment, and it is not reasonable, for example, for people to own machine guns. That law has been in place since 1937. We had an assault weapons ban from 1995 to 2005, but the Bush administration allowed it to lapse, so it was never renewed. During that 10 years, mass shootings and serious shootings with multiple victims diminished to a great degree. But the minute that statute sunsetted, all of a sudden everybody was buying AR-15s and AK-47s. Although they are semi-automatic versions, you can buy a $50 kit to convert your weapon into a fully automatic weapon, which is illegal to own, but lots of luck finding out who owns them. So the truth of the matter is that the Second Amendment has been misread. The Heller decision misread it, but it is we are a victim of the National Rifle Association and the lobby in Congress that prevents, and state legislatures that prevent the passage of gun control, legitimate gun control laws that are reasonable and applicable.
And so the state, the nation, doesn't want to do it, so it's falling on parents. Mr. Crumbley faces charge 2. What do you think is going to happen in that case?
Well, I don't know where he's going to have his trial. He will try to change the situs of the trial from Oakland County. That would mean it would probably go to somewhere like Grand Rapids, which is a different area, more gun-friendly area. He might do better in front of a gun-friendly jury who don't want the kind of restrictions placed on them and or the liability placed on them, and they take it personally. I don't know what's going to happen there because the question will be whether they can get a jury when they try to pick one. If they don't, they will move to situs.
Okay.
If he stays in Oakland County, he will face the same fate as Mrs. Crumbley. He will be found guilty, if not because he really is liable, but because there is anger in the community, and the state was trying the case to try to get the jury angry throughout the entirety of the case so that they want to take the deaths out on someone, and they seem to be the fall person.
And understandably, with murders of this kind, people want to find somebody responsible, so it's a natural human emotion. Well, Mr. Swartz, thank you so much for joining me and for the constitutional legal explanation. I'm very grateful.
My pleasure. Have a great day.